Nanaginip ako. Nag-break na daw kami, iyak ako ng iyak. Kaso nagising na ako. Tawa daw ako ng tawa. Wala ko pala ako jowa. Nakakainis ka! Minessage kita, sabi ko kumain ka na. Mag-ingat ka, have a good day. Tapos reply mo lang, okay? Bakit ang tipid mo mag-reply? May pinag-iipunan ka ba?
Hello everyone and welcome back to my channel. Nandito po ako sa kwarto ngayon ni Miss D na ngayon ay nasa Oriental, Mindoro. Na-miss ko siya kaya naisipan ko munang tumambay sa kwarto niya. Yung nakita nyo kanina doon sa TikTok, ang tawag po namin mga abogado doon ay in flagrante delicto. This is a legal Latin maxim which means caught in the act. O sa Tagalog po ay huli sa akto. So, pwede nyo rin pong gamitin sa pang-araw-araw na buhay ang legal Latin maxim na to. Yung mga misis dyan na nahuli sa akto ang kanilang mga mister na ng bababae para masindak nyo sila, pwede nyo sabihin sa kanila na, "Hoy, I saw you in flagrante delicto." So, I think one of these days I will be doing a vlog with regard to legal Latin maxims na usually ginagamit namin sa mga court hearings namin at sa mga pleadings namin. Pero pwede nyo rin gamitin sa pang-araw-araw na buhay. So, watch out for that vlog. Speaking of legal Latin maxims, so marami pong mga kababayan natin recently ang naging interesado sa batas. Pagkapasok pa lang po kasi ng May ay sunod-sunod na ang legal issues na ating kinaharap. Una na nga po dyan ay ang pag-extend ng enhanced community quarantine sa iba't ibang parte ng Pilipinas, including sa Metro Manila. Nagpalabas din ng IATF EID ng omnibus guidelines on the implementation of community quarantine in the Philippines. Pangalawa na legal issue is na lumabas ngayong May is yung PhilHealth Memorandum Circular number 2020-0014 na kung saan ay ginawang mandatory ang pagsingil o pagbabayad ng PhilHealth premium contribution sa ating mga OFW. Ito po ay nireklamo na maraming mga OFW at dahil po dyan ay nagpalabas ang ating presidente through Secretary Roque ng statement na dahil nga po may kinakaharap tayo na krisis ay ginawang voluntary na lamang ang pagbabayad ng premium contribution sa PhilHealth ng ating mga OFW. Later on, magpapalabas din ako ng vlog with respect to Universal Health Act. Watch out also for that vlog. At ang pinakahiling legal issue nga po na nakagulantang sa marami sa atin at kinalungkot din ng marami sa atin. Actually, pati po ako. Kasi marami rin akong mga talents doon at marami rin po akong mga kaibigan doon sa estasyon na yon. Ito po ay ang pag-sign off ng ABS-CBN Channel 2 noong May 5, 2020. This is in compliance with the Cease and Desist Order or CDO issued by the National Telecommunications Commission or NTC. Dahil nga po of the failure of the ABS-CBN Corporation to secure the necessary congressional franchise prior to the expiration of its franchise on May 4, 2020. So, dahil nga po ang ABS-CBN Corporation na isang radio and television broadcasting company, para po makapag-operate siya ay kinakailangan niya ng congressional franchise. So, what do we mean by congressional franchise? Ito po ay isang batas na ipapasa ng ating kongreso na inaalaw ang prangkisa ng ABS-CBN para mag-operate. At ang pinakahuling batas nga po na ipinasa ng ating Kongreso with respect to the franchise of ABS-CBN was Republic Act No. 7966, Act granting the ABS-CBN Broadcasting Corporation a franchise to construct, install, operate, and maintain television and radio broadcasting stations in the Philippines and for other purposes. So ito po ay in-issue noong March 30, 1995, and it has a term of 25 years. Kaya po 25 years after, ngayon pong taon na to, nag-expire ang prangkisa ng ABS-CBN. Due of insistent public demand, for this episode of Magtanong, I will be discussing the laws and the Supreme Court decisions with respect or related to construction, installation, maintenance, and the operation of radio and television stations. Okay, simulan na po natin ang pagdidiscuss ng mga batas in relation to construction, installation, operation and maintenance of radio and television broadcasting stations. So una po dito ay ang Act 3846 na inanak po noong November 11, 1931. So this is an act providing for the regulation of radio stations and radio communications in the Philippines and for other purposes. So ang important provision po ng batas na ito is under Section 1, which states that no person, firm, company, association, or corporation shall construct, install, establish, or operate a radio transmitting station or radio receiving station used for commercial purposes or radio broadcasting station without having first obtained a franchise therefore from the Congress of the Philippines. So, malinaw po doon na lahat ng radio stations, dahil nga po noong 1931 ay radio stations pa lang ang mga nag-ooperate. Bago po makapag-operate, kailangan po munang kumuha ng franchise from the Congress of the Philippines. So ang sumunod pong batas ay napasa noong 1974 during martial law po, and this is Presidential Decree number 576-A, regulating the ownership and operation of radio and television stations and for other purposes. So, ang important provision po nito is Section 1. No radio station or television channel may obtain a franchise unless it has sufficient capital on the basis of equity for its operation for at least 1 year, including purchase of equipment. So, in Section 1, malinaw po na hindi lang radio stations but even television stations, kailangan din po nilang kumuha ng franchise from the Congress of the Philippines. Another important provision of PD number 576-A is Section 6, which provides that, among others, thereafter, irrespective of any franchise, grant, license, permit, certificate, or other forms of authority to operate, granted by any office, agency, or person, no radio or television station shall be authorized to operate without the authority of the Board of Communications and the Secretary of Public Works and Communications. So malinaw po dito na yung mga may prangkisa na radio and television stations ay kinakailangan din pong kumuha ng authority to operate from then Secretary of Communications, at yun nga po ang naging NTC or National Telecommunications Commission sa ngayon. A few years later, or in 1979, napasa naman po ang Executive Order number 546. Ito po ay it integrated the Board of Communications and the Telecommunications Control Bureau under the Integrated Reorganization Plan of 1972 into what we call now as the National Telecommunications Commission or NTC. So ang mga powers po ng NTC under this law, Section 15 thereof states that NTC, Paragraph A, shall issue certificate of public convenience for the operation of communication utilities and services, radio communication systems, wire or wireless telephone or telegraph system, radio and television broadcasting system, and other similar public utilities. So, ang NTC po ang nag-i-issue ng certificate of public convenience. Another power of NTC is under Paragraph C, which states that it grants permits for the use of radio frequencies for wireless, telephone, and telegraph system and radio communication systems including amateur radio stations and radio and television broadcasting system. So another important provision po of this law is Section 16, which states that the Commission shall be under the supervision and control of the Ministry, except that with respect to its quasi-judicial functions, its decisions shall be appealable in the same manner as the decisions of the Board of Communications had been appealed. So, ang ibig sabihin lang po nito with regard to the quasi-judicial functions of the NTC, hindi po ito appealable sa Office of the President. Appealable po ito sa ating mga korte. So, i-appeal po ito sa Court of Appeals under Rule 43 of the Rules of Court. So, nakalagay po sa Rule 43 of the Rules of Court na ang mga awards, judgments, final orders, or resolutions of or authorized by any quasi-judicial agency in the exercise of its quasi-judicial functions ay appealable sa Court of Appeals. At isa nga po sa mga quasi-judicial agency na na-mention under Section 1 of Rule 43 ay ang National Telecommunications Commission. Pero kung meron naman pong grave abuse of discretion amounting to lack or excess of jurisdiction na na-issue mga orders ng NTC, ito po ay pwedeng i-contest via petition for certiorari under Rule 65 of the Rules of Court. So, based on the foregoing laws po, ano po ang mga requirements ng mga radio and television broadcasting stations para po sila makapag-operate? So, number 1, congressional franchise. Number 2, permit to construct or install a station. Number 3, certificate of public convenience. And number 4, permit for the use of radio frequencies. So, ang franchise po, ito po ay kinukuha sa Kongreso. And the rest po is the certificate and the permits ay kinukuha na po sa National Telecommunications Commission or NTC. Ngayon, magpunta naman po tayo sa mga Supreme Court decisions in relation to the construction, installation, operation, and maintenance of radio and television broadcasting stations. So, bakit po natin kailangang i-discuss ang mga Supreme Court decisions? Ito po ay dahil ang mga Supreme Court decisions are considered part of the law of the land. So, ang Supreme Court po kasi ang nag-i-interpret ng ating mga batas. So, yung mga interpretations ng Supreme Court sa mga kaso na isinasampa sa kanila ay magiging parte ng batas na in-interpret nila. So, importante po nating malaman ang mga Supreme Court decisions para po malaman natin kung ano po ba yung mga precedent or interpretation ng mga provisions doon sa mga batas regarding nga po dito sa construction, installation, operation, and maintenance of radio and television broadcasting stations. So, una pong i-discuss natin na Supreme Court decision or ang tinatawag po namin mga lawyers na jurisprudence ay ang Radio Communication of the Philippines Incorporated versus NTC or National Telecommunications Commission, GR number L68729, decided by the Supreme Court on May 29, 1987. So, ano pong importante sa kaso na to? In this particular case po, dinistinguish ng Supreme Court ang franchise from Certificate of Public Convenience. Sinabi po ng Supreme Court na ang franchise is a grant. This is a privilege given by the sovereign power through the Congress of the Philippines. While a Certificate of Public Convenience naman po is part or form of the regulation of an administrative agency like the NTC. In this particular Supreme Court decision din po, ni-recognize ng Supreme Court the necessity of both a congressional franchise under Act Number 3846 and a Certificate of Public Convenience under Executive Order Number 546 to operate a radio communications system. So, ang sunod naman po nating Supreme Court decision na i-discuss ay ang Crusaders Broadcasting System Incorporated versus National Telecommunications Commission. GR number 139583, May 31, 2000. So, in this particular case po, the Supreme Court said that the requirement of a congressional franchise for the operation of radio and television station exists alongside the requirement of a certificate of public convenience, and that in EO number 546 po, EO number 546 did not repeal Act number 3846, which provides that kailangan po ng prangkisa na kukuhain sa Kongreso ng mga radio and television broadcasting stations para po makapag-operate. Ang sinabi po ng Executive Order 546 ay nagbigay lang po ito ng regulatory functions sa NTC, pero hindi po nito ni-repeal ang Act number 3846. So, ang huling Supreme Court decision na i-discuss natin ay ang Supreme Court decision on the case of Associated Communications and Wireless Services United Broadcasting Network versus National Telecommunications Commission or NTC. And this was decided by the Supreme Court on February 17, 2003, GR number 144109. So, ano po ba ang nangyari sa kasong ito? So, in this particular case, ang ACWS po, or ang petitioner in this case, ay naisyuhan ng kanilang franchise to operate in 1965. So, it has a term of 50 years. Kaya lang po naabutan ng PD or Presidential Decree number 576-A ang operation ng ACWS. And nakalagay po sa Section 6 ng PD 576-A na ang lahat ng franchises issued to radio and television broadcasting stations ay ito-terminate on December 31, 1981. So, dahil nga po dito, noong December 31, 1981, ay na-terminate ang franchise ng ACWS. Kaya ang ginawa ng NTC, nag-issue na lang sila ng temporary permit sa ACWCS para makapag-operate sila. And to avoid any confusion on whether or not the NTC can issue temporary permit despite the lack of franchise of ACWCS, ay nag-sought ng opinion ang NTC sa Department of Justice. And the Department of Justice issued its legal opinion stating na pwedeng mag-issue ng temporary permit ang NTC sa ACWS. So, yun, nakapag-operate ang ACWS. Kaya lang nung mag-expire na yung kanilang temporary permit, ay hindi sila nakakuha ng franchise from the Congress of the Philippines. Kasi nung 9th Congress, hindi na-hear yung kanilang application. Tapos nung nag-apply sila ulit, hindi na mayroong mga documents na hindi sila na-submit. So, ang ginawa ng ACWS is nag-apply sila ng renewal ng kanilang permit sa NTC. And the NTC said na, sige, i-renew namin yung inyong temporary permit to operate basta magbayad lang kayo ng prescribed fee. However, makatapos makapagbayad ng prescribed fee ng ECWS, ay hindi in-issue ng NTC ang kanilang renewed permit to operate. Rather, what NTC did was issued a cease and desist order or CDO at later on recall ng NTC ang frequency given to Channel 25 of the ACWS. So because of that, ACWS went to the Court of Appeals and questioned the decision of the NTC. And the Court of Appeals affirmed the decision of the NTC. Thus, the ACWS went to the Supreme Court to appeal the decision of the Court of Appeals affirming the decision of the NTC. And isa sa mga issue na na-raise is number one, whether or not pwede ba na mag-issue ng temporary permit to operate ang NTC despite the lack of license or franchise or despite the expired franchise of ACWS? And the Supreme Court said no. And I quote, "The appellate court correctly ruled that a congressional franchise is necessary for petitioner to operate television channel 25. The Supreme Court added na ang function po ng NTC to issue permits may only take effect and be given effect after the grant of the franchise of the radio and television broadcasting stations by the Congress." So the Supreme Court said, and I quote, that the former, which is the function of the NTC, covers matters dealing mostly with the technical side of radio or television broadcasting, while the latter, which is the issuance of franchise by the Congress, involves the exercise by the legislature of an exclusive power resulting in a franchise or a grant under authority of government, conferring a special right to do an act or series of acts of public concern. Although sinabi po ng Supreme Court na may mga ibang public utilities naman na nag-ooperate without a franchise. Katulad nga po ng pag-ooperate ng domestic air transport and ports authority. Hindi po kinakailangan niya ng franchise kasi walang batas na nagsasabi na kailangan nila ng franchise. But in the operation of radio and television broadcasting stations, iba po ang case because according to the Supreme Court, where there is a law such as PD number 576A which requires a franchise for the operation of radio and television stations, that law must be followed until subsequently repealed. So kailangan pong i-repeal ang PD number 576-A kung gusto ng ACWS na wala ng franchise na kuhanin sa Congress para makapag-operate. So, isa pa na issue na na-raise sa Supreme Court sa kasong ito is yung DOJ opinion according to ACWS was sought by NTC. So, maliraw na hindi sinunod ng NTC yung DOJ opinion, especially na ang DOJ ay abogado ng gobyerno. So, however, according to the Supreme Court, and I quote, "Petitioner, however, cannot rely on DOJ opinion number 98 as the opinion is merely persuasive and not necessarily controlling. As shown above, the opinion is erroneous insofar as it holds that EO number 546 dispenses with the requirement of a congressional franchise to operate radio and television stations." So, sinasabi po ng Supreme Court na persuasive lang ang DOJ opinion at NTC is not required to follow the DOJ opinion with respect to this matter. So, another issue that was raised in this case is according to ACWS, dati nag-issue na ng permit, temporary permit ang NTC for them to be able to operate despite the lack of franchise. So, sabi nila, stop na raw ang NTC na mag-issue na hindi sila issuehan ng or i-renew ang kanilang permit to operate because of the principle of estoppel. So, ang estoppel po is, ang ibig sabihin po noon is yung parang paso na dapat ang NTC na hindi mag-issue ng permit kasi dati nag-issue na sila. But according to the Supreme Court, estoppel does not apply to the government, and I quote, The NTC's erroneous approval of petitioner's application in January 1998 did not stop the NTC from ordering petitioner on February 26, 1998 to cease and desist from operating Channel 25 for failure to comply with the franchise requirement, as estoppel does not work against the government. So, marami rin pong mga sinabi rin po ng Supreme Court in that case na ang dami pong nag-criticize na dapat daw po hindi na i-require ng congressional franchise ang operations ng radio and television broadcasting station. However, according to the Supreme Court, and I quote, "The call to dispense with the requisite legislative franchise must however be addressed to Congress as the lawmaker of the land, for the court's function is to interpret and not to rewrite the law. As long as the law remains unchanged, the requirement of a franchise to operate a television station must be upheld." Thus, in the end, the Supreme Court ruled. Wherefore, the petition is denied and the Court of Appeals January 13, 2000 decision and February 21, 2000 resolution are affirmed. So ordered. So, ito po yung mga batas at ang Supreme Court resolutions related to the operation, construction, instruction, and maintenance of installation, operation, and maintenance of radio and television broadcasting stations. Medyo mahaba po, pero hopefully nakasunod po kayo and hopefully nakapag-enlighten po kami sa inyo regarding this legal issue. Again, stay safe, stay home po muna tayo. Maghintay po tayo sa magiging desisyon ng ating gobyerno after May 15. And of course, don't forget to subscribe. Bye!
Don't forget to subscribe to our YouTube channel, Mugshots with Attorney Maggie.